Are you unhappy with the judge's decision in your Connecticut divorce or custody case and you want that judge to change their decision? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a motion to reargue in Connecticut Family Court. A motion to reargue is a motion asking the judge to reconsider their decision because they misapplied the law or failed to consider facts that were presented at trial. A motion to reargue is not a second chance at trial in which you get to present new evidence, so just make sure that during your trial you present all the evidence and everything you want to say during your trial. A motion to reargue is also different from an appeal. An appeal is an action filed with a higher court asking the court to overturn the original judge's decision. But this is just a request that the original judge change their decision, and that is a request that is filed with the judge who heard the trial. Now, a motion to reargue must be filed within 20 days of the judge's decision, and it has to include certain things. It has to list the decision or order which is the subject of the motion, so the title, date, and pleading number of the judge's memorandum of decision. It has to include the name of the judge who issued the decision and the specific reasons why you feel reargument is appropriate, including how the judge misapplied the law or what facts you feel the judge overlooked. Now, this is a sample motion of what you actually have to file with the court, so include your case caption and then the title of the motion below. You should put plaintiff if you're the plaintiff or defendant if you're the defendant, and then stating that in the above captioned matter, you're asking the court, and then include the judge's name and the date of the judgment and the pleading number, and then the underlying motion. So this sample motion is for underlying motion to modify alimony in a motion for contempt, but if it is just a regular trial, it may be on the divorce complaint or the divorce cross complaint. And then below that, you just insert the reasons of why you are seeking reargument and you want the judge to change their decision. They may have misapplied the law, or they may have overlooked facts. So just be detailed in why you are seeking that the judge changes his or her decision. And then you include a brief conclusion at the end. Now, you have to make sure that you include this bolded language at the bottom of the first page so that you're asking for oral argument and testimony may be required. And then this section is very important, that it is a practice book section 11-11 motion that will delay the commencement of the appeal period. So normally you have 20 days to file an appeal in Connecticut Family Court, but if you file a motion to reargue, the 20 days is told and it actually restarts after the judge issues a decision on this motion to reargue. And then you just put your signature on the bottom of the motion and a certification showing that you served the other party with the motion to reargue. Now, once you file the motion to reargue, the judge can do a few different things. They do have the right to just deny the motion outright without any hearing. You are not entitled to have oral argument on a motion to reargue. But if they don't just deny it outright, and they are considering granting it, they will schedule it for a hearing at which you will appear in court and you will have the opportunity to argue why the judge made a mistake and how they should change their decision. You will not have an opportunity to present new evidence, so there will not be further testimony or evidence presented, but you can just make arguments and make reference in those arguments to the evidence that was already presented during the trial. Now, whatever the judge decides, that decision is final. And then after that, again, you have 20 days following the decision on the motion to reargue in which you can file an appeal. So those are the basics on how to file a motion to reargue in Connecticut Family Court. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.